Welcome back to SCOTUS Oral Arguments and Opinions. In this episode, we'll discuss the June 27th, 2025 Supreme Court opinion in the case called Kennedy v. Braidwood Mgmt, Incorporated, case number 24-316. Please note that this summary is read by an automated voice. In this case, the Supreme Court ruled 6-3 that members of the U.S. Preventive Services Task Force are inferior officers who can be constitutionally appointed by the Secretary of Health and Human Services, rather than requiring presidential nomination and Senate confirmation. The case arose when businesses challenged the task force's authority to issue binding healthcare coverage recommendations under the Affordable Care Act, arguing the members were unconstitutionally appointed principal officers. Justice Kavanaugh's majority opinion held that task force members are inferior officers because the Secretary can remove them at will and has statutory authority to review and block their recommendations before they take effect. The decision preserves the current appointment structure while ensuring executive accountability over these consequential healthcare policy recommendations. In this episode, we'll examine Justice Kavanaugh's majority opinion, holding that statutory provisions give the Secretary sufficient supervisory authority over the task force, against Justice Thomas's dissent, arguing that Congress never explicitly vested appointment power in the Secretary and that the majority distorted Congress's design for an independent agency. Then we'll analyze how this case reflects broader tensions within the court about constitutional interpretation, statutory defaults, and the proper balance between administrative expertise and democratic accountability in federal agencies. The question presented in this case is whether the Court of Appeals erred in holding that the structure of the task force violates the Appointments Clause of the Constitution and in declining to sever the statutory provision that it found to unduly insulate the task force from the HHS Secretary's supervision. As I mentioned in an earlier episode, 3 days after oral arguments, the Supreme Court issued an order directing the parties to file supplemental briefs addressing the following question: whether Congress has, by law, vested the Health and Human Services Secretary with the authority to appoint members of the United States Preventive Services Task Force under the Appointments Clause of the Constitution. Justice Kavanaugh delivered the opinion of the court in which Chief Justice Roberts and Justices Sotomayor, Kagan, Barrett, and Jackson joined. Justice Thomas filed a dissenting opinion in which Justices Alito and Gorsuch joined. Before diving into the opinion, I wanted to give you all the exact text of the Appointments Clause in the Constitution. He shall have power, by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur. And he shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers, as they think proper, in the President alone, in the courts of law, or in the heads of departments. The relevant issue here involves the latter half of the clause. He shall nominate, and by and with the advice and consent of the Senate shall appoint all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers, as they think proper, in the President alone, in the courts of law, or in the heads of departments. In plain English, the questions are: 1. Whether the task force members are inferior or principal officers. If they're principal officers, then the task force is unconstitutional because 2/3 of the Senate did not confirm their appointments. If they're inferior officers, then we proceed to the second question: whether Congress vested the President or HHS with the authority to appoint the task force members. If so, then the task force is constitutional. If not, then the task force is unconstitutional.
Justice Kavanaugh's majority opinion. In 1984, the Department of Health and Human Services, HHS, created the U.S. Preventive Services Task Force, a body that formulates evidence-based recommendations regarding preventive healthcare services. Congress codified the task force's role in 1999, establishing it as an entity within the Agency for Healthcare Research and Quality, AHRQ, in HHS's Public Health Service. The task force currently consists of 16 volunteer members appointed by the Secretary of HHS to staggered 4-year terms. Before 2010, task force recommendations were purely advisory. The Affordable Care Act of 2010 changed this by requiring most health insurers and group health plans to cover without cost sharing those preventive services that receive A or B ratings from the task force. The Act also amended the governing statute to describe the task force as independent and to provide that members and their recommendations shall be independent and, to the extent practicable, not subject to political pressure. Plaintiffs, individuals, and small businesses who object to the Affordable Care Act's preventive services coverage requirements sued in federal court. Lead plaintiff Braidwood Mgmt runs a health and wellness center offering insurance coverage to its approximately 70 employees through a self-insured plan. Plaintiffs argued that task force members are principal officers under the Appointments Clause, who must be appointed by the President with the advice and consent of the Senate, Article 2, Section 2, Clause 2, not by the Secretary. The District Court agreed, recognizing that task force members are removable at will by the Secretary, but concluding they are principal officers because they have no superior who supervises and directs them. While the government's appeal was pending, the Secretary in June 2023 ratified existing appointments made by the AHRQ Director and began personally appointing task force members. The Fifth Circuit affirmed the District Court, holding that while task force members are removable at will, they are not inferior officers because they cannot be independent and free from political pressure, while simultaneously being supervised by a political appointee. Held, task force members are inferior officers whose appointment by the Secretary of HHS is consistent with the Appointments Clause. A. The Appointments Clause in Article 2 specifies how officers of the United States must be appointed, dividing all officers into two classes. Principal officers must be appointed by the President with the advice and consent of the Senate. Inferior officers likewise may be appointed by presidential nomination and Senate confirmation, but Congress may also, by law, vest their appointment in the President alone, in the courts of law, or in the heads of departments. Article 2, Section 2, Clause 2. Principal officers encompass at least department heads who report directly to the President. Inferior officers are those whose work is directed and supervised at some level by others who were appointed by presidential nomination with the advice and consent of the Senate. B. Task force members are inferior officers because their work is directed and supervised by the Secretary of HHS, a principal officer, through two main sources of authority. 1. The Secretary's authority to remove task force members at will provides a powerful tool for control. An officer's presumed desire to avoid removal generally creates here and now subservience. Here, the Secretary has power to appoint task force members, and no statute restricts their removal. Therefore, the Secretary may remove task force members at will, enabling him to supervise and direct them. 2. Beyond at-will removal, the Secretary has statutory authority to directly review and block task force recommendations before they take effect. Several statutes give the Secretary General supervisory authority over the public health service within which the task force is housed, as well as rulemaking authority with respect to the Affordable Care Act's coverage provisions. During the minimum one-year interval before recommendations become binding, the Secretary can use his supervisory authority to direct that task force recommendations he disagrees with not be in effect and therefore not be binding, or he can establish formal review processes through rulemaking. Task force members, therefore, have no power to render a final decision on behalf of the United States unless permitted to do so by the Secretary. C. The conclusion that task force members are inferior officers follows a fortiori from this court's precedents. In Edmund, Coast Guard judges who were removable at will and whose decisions could be reviewed and reversed were deemed inferior officers, even though superiors could not influence individual proceedings. Like those judges, task force members are removable at will, and their decisions can be reviewed and overruled by the Secretary. In Free Enterprise Fund v. Public Company Accounting Oversight Board, PCAOB members removable at will by the SEC were inferior officers, even though they were empowered to take significant enforcement actions, largely independently of the Commission. In Arthrex, administrative patent judges, whose decisions were reviewable but who were removable only for cause, were inferior officers. If patent judges subject only to review authority were inferior officers. Task force members, subject to both at-will removal and review authority, are clearly inferior officers. D. Braidwood's arguments against inferior officer status fail. 1. The independence provision stating that task force members shall be independent and, to the extent practicable, not subject to political pressure, does not create for-cause removal protection. To displace the default of at-will removal, Congress must use very clear and explicit language. Mere inference or implication does not suffice. The term independent alone does not make an officer removable only for cause, as this court held in Collins v. Yellen. 2. Braidwood claims that 42 U.S.C. Section 299B-4A left parenthesis 6, right parenthesis requirement that task force members be independent and, to the extent practicable, not subject to political pressure must mean that the task force is completely insulated from the Secretary. But independent is best read to mean that task force members must not be unduly influenced by their outside professional affiliations with universities, hospitals, and professional associations. Even if the independence provision meant some insulation from the Secretary when practicable, that would affect only the formulation of recommendations, not the Secretary's authority to review them before they take effect. This mirrors the almost universal model of adjudication in the executive branch, where inferior officers make independent initial decisions subject to review by politically accountable superiors. The Secretary's inability to compel the task force to issue particular A or B recommendations does not undermine inferior officer status. This court has not suggested that a principal officer must be able to compel subordinates to take affirmative acts for them to qualify as inferior officers. In Free Enterprise Fund, the SEC lacked power to require the PCAOB to start investigations, yet PCAOB members were inferior officers. Similarly, in Edmund and Arthrex, superiors could not compel initial decisions. 4. When Congress wants to create an independent agency, it generally does so by explicitly conferring for-cause removal protection on the agency's leadership, and usually couples that protection with express presidential nomination and Senate confirmation requirements. The statute establishing the task force contains none of this customary language. E. Congress has by law vested appointment authority in the Secretary of HHS through 2 steps. First, the 1999 statute governing the task force gives the AHRQ director the authority to convene a task force to be composed of individuals with appropriate expertise. Section 299B-4, a left parenthesis, 1 right parenthesis. Congress need not use magic words to confer appointment authority. And around the time of the founding, appoint was synonymous with allot, assign, or designate. In the absence of a statutory provision that more explicitly confers appointment authority, the AHRQ director's power to convene is naturally read to include the power to appoint. Second, Reorganization Plan Number 3 of 1966, ratified by Congress in 1984, transfers to the Secretary all functions of the Public Health Service and its officers, employees, and agencies. The AHRQ director is an officer of the Public Health Service, so reorganization plan number 3 transfers all of the AHRQ director's functions to the secretary. After statutory codification of the task force in 1999, those powers of the secretary included the AHRQ director's power to appoint the task force members. Therefore, by virtue of the 1984 Act ratifying Reorganization Plan Number 3 and the 1999 Act conferring appointment authority, Congress vested the power to appoint task force members in the Secretary of HHS. F. Braidwood's arguments that Congress has not properly vested appointment authority in the Secretary fail. Braidwood first claims that the 1999 statute using convene does not confer appointment authority and is instead agnostic about who should appoint task force members. Braidwood's interpretation would create a bizarre scheme where Congress was entirely indifferent about who would appoint members making legally binding healthcare recommendations. Braidwood next argues that even if the director has appointment authority, Reorganization Plan Number 3 does not transfer that power to the secretary because it applies only to the director's functions as of 1966. This frozen-in-time reading finds no footing in statutory text or common sense. The plan's language, all functions, most naturally means an ongoing transfer of authority, including new powers granted by Congress after. G. The Secretary has properly exercised his appointment authority since June 2023. Reversed and remanded.
Justice Thomas's dissenting opinion. To promote democratic accountability, the Appointments Clause establishes a default rule that all executive branch officers must be appointed by the President with the Senate's approval. Article 2, Section 2, Clause 2. Congress may depart from this default by authorizing a department head to appoint inferior officers, but only if it does so expressly. This case concerns the U.S. Preventive Services Task Force, a body that issues legally binding recommendations regarding preventive healthcare treatments. At the beginning of this suit, a subordinate official within the Department of Health and Human Services, HHS, had for years appointed the task force's members. Everyone now agrees that this practice was unlawful. Everyone further agrees that no one statute provides for a department head to appoint the task force's members. But rather than accept that the default mode of appointment applies, the government invented a new theory on appeal, arguing that the combination of two ambiguously worded statutes enacted decades apart establishes that the Secretary of HHS can appoint the task force's members. I cannot embrace this theory. I would not rule on the government's new theory before any lower court has done so. But if we are to decide this question now, I do not see how Congress has spoken with the clarity needed to depart from the default rule established by the Appointments Clause. In ruling otherwise, the court treats the default rule as an inconvenient obstacle to be overcome, not a constitutional principle to be honored. And it distorts Congress's design for the task force, changing it from an independent body that reports directly to the president to one subject to the control of the Secretary of HHS. I would remand for the Fifth Circuit to consider the important threshold question that it skipped, whether the Secretary has the statutory power to appoint the task force. The answer to the first question significantly affects the analysis of the second question. But no court has passed on the first question, and this court has had only a limited opportunity to consider it. If forced to decide, I would affirm on the ground that Congress has not given the Secretary of HHS the power to appoint task force members. The members must therefore be appointed by the President with Senate confirmation. A department head may appoint an inferior officer only if Congress has, by law, vested the appointment of such officer in him. Article 2, Section 2, Clause 2. The vesting of appointment authority must be explicit. The Appointments Clause's default rule of appointment by the President with Senate confirmation specifically addresses how an inferior officer is to be appointed. Appointment authority, therefore, cannot be deemed implicit in a more general grant of authority to a department head. Only a provision that specifically addresses appointment can displace the default. The director's power to convene the task force does not include the power to appoint its members. This premise conflicts with both ordinary meaning and the canon of constitutional avoidance. To convene a group means to cause it to assemble. That task is different from selecting the membership of the group. The director's power to convene the task force, thus, cannot be the explicit grant of appointment power needed to displace the default established by the Appointments Clause. Even if Congress unconstitutionally vested appointment power in the director, the reorganization plan does not transfer that power to the HHS Secretary. For 4 reasons. The power to appoint the task force cannot be a function transferred by the plan. First, the reorganization plan does not apply to functions that did not exist when the plan was issued in 1966. Second, the Reorganization Act prevents us from reading functions to encompass the authority to appoint officers. Third, the appointment of the task force cannot be a function of the AHRQ director because the director cannot validly appoint its members under the Appointments Clause. Finally, reading the plan to transfer appointment authority creates constitutional problems. The majority's erroneous statutory holding may save the Secretary's mid-appeal claim of authority, but it makes hash of Congress's design. Congress established the task force to be an independent agency that answers directly to the President. By misinterpreting the statute, the court reconfigures the task force to be subordinate to the Secretary of HHS. The task force is not part of AHRQ. Section 299B-4A11 provides that the AHRQ director shall convene an independent Preventive Services Task Force. When modifying a federal agency, the term independent often means not part of and therefore independent of any other unit of the federal government. Congress enacted a constitutional independent task force subject to the President's control, but not to the control of the Secretary of HHS. To save the task force from its threshold error, the majority alters Congress's legitimate design. Under our Constitution, appointment by the President with Senate confirmation is the rule. Appointment by a department head is an exception that Congress must consciously choose to adopt. The framers established this rule to ensure that the President is accountable for the selection of officers in the executive branch, and it is the law, whether we agree with it or not.
All right, those were the majority, concurring, and dissenting opinions. Now, let's talk case implications. This decision resolves an important but narrow question about the constitutional structure of federal health policymaking, while leaving several broader issues unsettled. The majority's ruling that task force members are inferior officers subject to secretarial appointment and supervision clarifies the chain of accountability for these consequential healthcare recommendations, ensuring they remain within traditional executive branch hierarchies. However, the court's reliance on a complex 2-step statutory interpretation, combining a 1999 convening provision with a 1966 reorganization plan, suggests future appointment authority disputes may turn on similarly intricate textual analyses. The decision appears to strengthen executive control over administrative bodies with significant regulatory impact, though the court was careful to emphasize the specific statutory framework governing the task force, rather than announcing broader principles about independent agencies. Justice Thomas's dissent raises fundamental concerns about the majority's approach to statutory interpretation and constitutional defaults that may resonate in future cases. His critique that the majority treated the default rule as an inconvenient obstacle to be overcome, not a constitutional principle to be honored, suggests ongoing tension within the court about how rigorously to apply Appointments Clause requirements. The dissent's emphasis on explicit congressional authorization for departure from presidential Senate confirmation could influence how lower courts analyze similar appointment schemes, particularly for bodies Congress describes as independent. Perhaps most significantly, the disagreement over whether the task force should answer directly to the President versus the HHS Secretary reflects deeper questions about how Congress can structure expertise-driven agencies within constitutional constraints, questions that remain largely unresolved despite this decision. Thanks for listening to this episode. I'll be back soon with more Supreme Court analysis. If you found this valuable, please subscribe and share with anyone who wants to understand how the court really shapes our lives. Up next, FCC v. Consumers Research. Talk to you soon.